Today we bring to you a civil case about a girl named Sophia. A few months ago she was found dead due to asthma attacks. Medical reports have shown that these attacks triggered due to some exported dried apricots while at Thailand. Now Sophia's parents have decided to take this case to the courts against the government for responsibility of Sophia's death. Let's find out what happens.
Firstly, it is evident that the packet of dried apricots Sophia consumed did not have a label attached to its packaging. According to Schedule 3 of the Food and Drugs Composition and Labeling Regulations, an additive constituting one of the ingredients of a food shall be listed by its functional class and its specific name, or identification number or prefix. In the case of the packaging of the dried apricots, the packet should have a label that specifies that sulfur dioxide is contained in the apricots, along with its identification number, that is E220 under the International Numbering System of Food Additives. Therefore, even if the labeling does not include the amount of sulfur dioxide contained, it should at least contain labeling that specifies that sulfur dioxide is contained. Our second argument relates to the fact that the Hong Kong government was not aware of the red import alert issued by the US FDA on Lucky Trading Company. The US Food and Drug Administration have issued an import red alert number 1990-21 that identifies Lucky Trading Company to have undeclared or excess of preservatives, that is SO2, in its products. Whilst FDA is a US agency, it is an internationally renowned body for protecting the public health by assuring the food are safe, wholesome, sanitary, and properly labeled, and is an organization that provides credible food and public health information to other countries as well. In this import alert number 9921, detention without physical examination and surveillance of food products containing sulfites, it clearly states that 10 milligrams of sulfites ingested at one sitting could pose a life-threatening hazard to a sulfite-sensitive individual. Detention is appropriate when sulfites are not declared and analysis shows the presence of sulfites greater than 10 ppm, that is equal to 10 milligrams. Yet in Schedule 1 in the Preservatives in Food Regulation, the maximum amount of residual sulfur dioxide allowed in dried apricots amounts to 2,000 ppm in Hong Kong, which exceeds the safe consumable amount. In conclusion, Sophia's oversensitivity to dried apricots was reasonably foreseeable. According to the Australian study of the amount of preservatives in dried fruits, the WHO warned that 20 to 30% of childhood asthmatics are sensitive to sulfite preservatives. There is an average of 16 milligrams of SO2 per dried apricot. Most importantly, children in general are more vulnerable to effects of SO2 than adults. Asthmatic people can be highly sensitive to such preservatives. Therefore, we believe that the Hong Kong government was negligent in protecting individuals who are sulfite sensitive.
According to the Regulation of Food Additives in Hong Kong, Chapter 132, BD, Section 7, the food manufactured in Hong Kong which solely for the purpose of export shall not have the need to be labeled. And in this case, the dried apricots bought in Thailand are considered as an exported goods from Hong Kong, which does not require labeling about, firstly, the specific name and the amount of the additives, and secondly, the identification number under the International Numbering System. As a result, the Hong Kong government is not liable in such case regarding the torts of negligence. Duty of care should rely on the foreseeability, proximity, and reasonableness. All three elements are needed in order to fulfill the requirement of the existence of this law. For imposing liability in negligence, it is a must to show a close and direct relationship of proximity. For proximity, is the necessary relationship between the plaintiff and the defendant. The pack of dried apricots Sophia consumed is bought from a retailer from Thailand. At the time the family bought the dried apricots, there was no relationship between Hong Kong government and the family. There was also no relationship between Hong Kong government and the Thai retailer. Therefore, proximity do not exist between the Hong Kong government and Sophia. For foreseeability, we believe that the death of Sophia is not foreseeable, as it involves quite a number of unpredictable incidents. For instance, the mislabeling of the apricots. For reasonableness, in this case, we agreed that death of Sophia is reasonable, as accidents by human mistakes do happen every day. Lastly, Sophia has the identity as a Thailand tourist when she is consuming the dried apricots. Therefore, the government will not have the duty of care with Sophia. It may fall to Thailand government's responsibility. The responsibility of Hong Kong government is to protect the general public, which means the Hong Kong citizens. Any policies are not aimed at an individual member of the public, but are designed to protect the public in general. With limited resources, the Hong Kong government has been trying to establish the most efficient and effective plans to serve our beloved citizens. In this case, a maximum per meter level of 2000 ppm sulfur dioxide in dried apricots, as stated in the Preservatives in Hong Kong Food Regulation, Hong Kong Common Law CAP 142, Section 55 and 143, is an optimal amount set after weighing the benefits of different parties in the society. 2000 ppm of sulfur dioxide can normally be endured by normal people who do not suffer from asthma. It is normally acceptable for asthmatic adults too. And there are only a small proportion of asthmatic children are oversensitive to sulfite preservatives. However, these children should be taken special care in many aspects other than the intake of sulfur dioxide. Since the amount of sulfur dioxide in dried apricots does not exceed the maximum level, as far as practicable, Hong Kong government has tried her best to fulfill her responsibility of protecting her citizens. So therefore, it is believed that a great deal of time, trouble, and expenses are expected to have to put in if the policy is to come up with laws and regulations to protect every individual in the society. The court has the power to divide liability of negligence between a number of parties. In the case, it is believed that it is a couple who should doubtlessly be responsible for not taking good care of their child who has been suffering from asthma. They should have possessed the knowledge of what food could cause danger to their daughter's life. A little girl like Sophia will not be able to differentiate from what food they can or cannot eat, as the plaintiff can be found to be partly at fault. Therefore, the parents of Sophia should be responsible for the safety of their child too.
We would like to express our greatest sympathy for Sophia passing away. The cause for asthma attacks is confirmed due to the dried apricot, which is unfortunate. We believe no one wants to see similar incidents happen again, and no one would have imagined this deadly outcome. We truly believe the feelings floating in Sophia's parents' minds. This loss is heartbreaking and can hardly be recovered. We understand the rationale behind Sophia's parents eager to take legal action against the Hong Kong government for indirectly causing their daughter's death, a bid to fight for the better off of their dearest child. Yet, after a thorough discussion and examination, we are sorry to conclude that this legal pursuit will be of no avail. The Hong Kong government does not owe the duty of care for Sophia's death, as foreseeability, proximity, and reasonableness cannot be all fulfilled. Second, the Hong Kong government has already made every endeavor possible to protect the general public in the catering sector. Regarding new legislation for asthma patients, the government still needs time and effort for better detailed research. Third, Sophia's parents should also bear responsibility for not taking cautious care of the daughter. Lastly, and most importantly, the dried apricots linked to this case are sold in both Thailand and Hong Kong, which means that good is not for sole export purpose. Thus, ingredients should have been clearly listed and labeled on the package. However, as the dried apricots were bought in Thailand, we will consider that as an exported good. Therefore, according to Section 7 in Preservatives in Food Regulation Chapter 132 BD, Lucky Trading Company will not be liable for the death of Sophia. Although this incident may be an exceptional case, we firmly believe and urge the Hong Kong government to take initiative to prevent occurrence of similar cases for the sake of consumer protection. Last, we are here to suggest a review on Section 7 in Preservatives in Food Regulation Chapter 132 BD, particularly regarding the issue of ingredient labeling, and it is believed that Section 7 is not adequate in ensuring the health of the general public. Thank you.